Welcome back to the Retirement Deep Dive. Today, we're tackling a very thorny subject: how the special allowance anomaly is a violation of Supreme Court judgment in Bank of Baroda vs. G. Palani case, civil appeal case number 5525-2012. I'm Priya Chakraborty, and my co host is Nisha Bhattacharya.
It's an incredible story. The judgment aligns with the golden rule of interpretation rather than the mischief rule. The Bank of Baroda's reliance on the explanation to Regulation 29 was an attempt to use a subordinate clause to defeat the primary legislative intent. In administrative law, particularly under the Wednesbury Principles of reasonableness, the bank's stance was irrational.
Unlike strict contractarian views often seen in early English common law, Indian constitutional law mandates that where two interpretations of a social welfare statute are possible, the one favoring the beneficiary must be adopted. DS Nakara Doctrine.
Furthermore, this decision reinforces the Indian Supreme Court's anti-formalist stance in labor law. The court here rightly refused to let the dead hand of a textual cutoff date strangle the substantive rights of the retirees.
It did. And it's not just, a simple dispute over a few extra rupees. This was a fundamental battle waged by thousands of retirees against, institutional power.
Absolutely, and it all centers on this one question. Can an employer just arbitrarily change the terms of your retirement after you've already, hung up your boots?
Yes, but what this case shows is that winning in court, even at the Supreme Court level, is often just the halfway point.
The real challenge is enforcing that victory when the entity you're fighting has such deeply entrenched regulatory power.
Today, we're going to trace how a pivotal 2018 Supreme Court judgment, the Bank of Baroda versus G. Palani case, set this incredibly strong precedent.
Only to be followed almost immediately by a whole new wave of disputes.
Exactly. Disputes over how to implement the ruling and, maybe even more shockingly, these subsequent regulatory workarounds.
The initial conflict, the one that lasted nearly 2 decades, was all about a technical detail, but a detail with massive financial consequences for retirees and super seniors.
And this was for employees who retired around the turn of the century, right? Specifically between April 1998 and October 2002.
That's the group. And the anomaly at the heart of this was the calculation of the basic pension. It all hinged on something called the Dearness Allowance, or DA.
Okay, so when it came time to calculate the final pension, the banks needed to merge a portion of this fluctuating DA into the basic salary.
Yes. And they were supposed to use the standard index point for everyone at the time, which was 1,684 points.
But they didn't.
No. The banks, through unilateral executive action, decided to fix the DA merger point for these specific retirees at a lower arbitrary figure of 1,616 points, which the court described as an irrational level.
That seems like a small technical difference, but what did it actually mean for the retirees?
It meant the banks were using an older, lower scale, so the impact on retirees' pension was immediate and severe. Their basic pension, which should have been 50% of their last drawn pay, was suddenly cut down to around 41%.
Wow, that's a drop of about 9 percentage points, a huge reduction. And it's all masked in regulatory jargon.
Exactly. And this change was introduced through a non-statutory joint note signed in 1999, which was then codified by adding a specific clause explanation, C, to the existing 1995 pension regulations.
That sounds like they were trying to drive a truck through a technical loophole.
It really was. The key thing here is the timeline. The original statutory pension rules were in place since 1995. This arbitrary change came later.
And the retirees argue that this executive action couldn't legally override the original rules.
And that fight started with a petition way back in 2001, and it finally culminated 17 years later.
17 years. Staggering. Just to confirm your basic entitlements.
Oh, okay.
So that brings us to the landmark moment in February 2018, the Supreme Court ruling in Bank of Baroda versus G. Palani.
And the judges did not mince words.
No, they sided definitively with the retirees and dismissed all the bank's appeals.
This ruling is just a masterclass in the legal meaning of retirement rights. The court first established that the 1995 pension regulations have statutory force.
And what does that mean exactly, statutory force?
It means they were framed under an Act of Parliament, the Banking Companies Act 1955. And because of that statutory foundation, they can't just be overwritten by a simple joint note or executive order.
So it's not just an internal company policy, it's the law.
And this is the major conceptual takeaway you really need to grasp.
Really, why?
They clarified the very nature of a pension. It is not a handout. The court stated very emphatically that pension is neither a bounty, charity, nor gratuitous payment. It's an earned accrued right. It's deferred compensation for past service.
And crucially, they defined it as being akin to property right under the Constitution.
Exactly, which means it's protected against arbitrary action. So if the banks tried to retrospectively change the calculation,
Banks were essentially trying to seize property that had already been earned by the employee.
that's precisely the legal reasoning. The Supreme Court then took that principle and used it to strike down that arbitrary clause, explanation C, on three specific grounds.
Okay, what was the first one?
The first ground was that it was repugnant to the existing pension regulations. It was contradictory
Contradictory to which rules?
to what we can call the last 10 months rule. The existing regulations required the pension to be calculated based on the average pay drawn during the last 10 months of service.
And by forcing the use of that older, lower DA merger point, they were breaking that fundamental 10-month rule.
Correct. They weren't using the actual final pay scale. The second ground was that the explanation was just arbitrary. Its only purpose was to artificially reduce the pension.
There was no other rational basis for it.
None. And third, you simply cannot enact such a rule retrospectively to snatch away rights that employees had already earned when they walked out the door.
So the order was clear: pay the arrears from 1998 to 2005 and do it within 4 months.
And with a penalty of 9% interest.
Okay, so let's unpack this implementation failure. A clear Supreme Court order, penalty interest, 4 months to comply. That should have been the end of the story.
It should have been.
But based on the source material, especially from retiree associations like AIBPIRSC, the problem started immediately.
They did. The first battle was over the scope of the judgment itself. The core group that filed the original petition retired between 98 and 2002, so some banks tried to limit the benefit only to those people.
But the retirees argued that the ruling struck down the clause itself. Explanation C. So anyone who retired later, say between November 2000 here and April 2005, was equally affected.
Of course, I mean, if the regulation is illegal for one group, it's illegal for all groups it applied to. It's just logical.
And the sources highlight how upsetting this is. Many of these later retirees are now in their 70s, still having to fight for entitlements the court affirmed years ago.
It turns a judicial victory into a bureaucratic siege. It's heartbreaking.
At this point, we would like to thank our subscriber Anil Mehta, who provided the materials for this podcast and gave us permission to use them.
Meanwhile, if you find this podcast useful, please click like, comment, share with family and friends, and subscribe.
Moving on, then we get to the issue of commutation, arrears, and interest, and this is where the complexity spikes and the resistance gets, well, particularly frustrating.
Okay, so a quick definition here. Commutation is when a retiree chooses to take a portion of their future monthly pension as a lump sum payment today.
So you get a bit less each month, but you get a chunk of cash right away.
Exactly. So when the basic pension was revised upwards by the court, the commuted lump sum value also had to be revised upwards. Retirees were due an additional lump sum payment.
Okay, makes sense so far.
But here's the trick the banks allegedly used. They improperly applied that 9% interest.
With the 9% interest the court ordered the banks to pay to the retirees?
Yes. But in their calculations, some banks treated the future recovery of that commuted portion as a past due debt owed to the bank starting from the day they retired.
Let me see if I get this. You, the retiree, are owed money. The bank delays paying you. Then when they finally pay you the lump sum difference, they charge you interest on the money you were going to pay back to them in the future.
You've nailed it. Even though they hadn't given you the full lump sum yet.
They charged the retiree interest on a loan before the loan was even fully disbursed?
Yes. But legally, the recovery of that commuted portion is only supposed to start after the lump sum has actually been paid. It's future recovery, not past debt.
That's such a critical distinction. It really shows intent. It shows they were applying the rules in the most unfavorable way possible.
And that's why many banks, including the State Bank of India, eventually had to reverse these calculations after facing contempt proceedings. It proved the retirees were right all along.
And here's where the legal loop seems to just repeat itself. It's almost cyclical. You have this massive victory in 2018 establishing that you can't arbitrarily reduce pension benefits.
But almost immediately, a new mechanism pops up that retirees argue achieves the exact same thing, just through a different regulatory door.
It suggests the institutional goal of reducing the final pension liability just persisted regardless of the Supreme Court's mandate.
And the new vehicle for this reduction is something called the special allowance.
Right. This was introduced in a new settlement, this 2015 joint note, and this allowance was a specific percentage of basic pay, somewhere between 7.75% and 11%.
But the exclusion clause is the telltale sign here. The note explicitly stated this special allowance shall not be reckoned for superannuation benefits, e.g., pension, including NPS, PF, and gratuity.
And the retirees claim this wasn't some extra benefit. They argue it was a portion carved out of the basic pay itself. So if your total salary is, say, 10 lakhs per annum,
Right.
and they call 9 lakhs basic pay and 1 lakh special allowance, but then only calculate your retirement based on the 9 lakhs.
You've just arbitrarily reduced the base for calculating pension by 10% without ever officially cutting the current wage.
Because the allowance is paid universally across the board for normal duty, it raised a precedent issue.
Exactly. So, principles from other Supreme Court cases suggest it should automatically form part of basic pay for terminal benefits. This whole thing feels like an attempt to bypass the spirit of the Palani ruling.
So the legal argument now becomes one of contempt, essentially. They're saying this new clause is functionally identical to the one the Supreme Court already struck down as arbitrary.
The modus operandi just shifted. Instead of manipulating the old DA merger point, they are getting the same result by just splitting the basic pay into two parts.
And the petitioners argue this violates the core of the 2018 judgment.
Because the Supreme Court explicitly struck down any policy that creates two different pay scales. One for your salary and a lower one for your benefits. That was deemed illegal and arbitrary then, and they're saying it's arbitrary now.
So the goal now is to get the judiciary to strike down this new regulation, arguing it's a deliberate maneuver to circumvent that clear 2018 mandate.
That's the fight today.
So what does this all mean for you, the person trying to understand this intersection of law and pensions?
This fight demonstrates that a judicial victory, even a landmark one from the highest court, isn't necessarily the final solution. There are no final victories or final defeats.
It's a textbook example of regulatory arbitrage, isn't it?
It is. It's finding a novel way to interpret or navigate legal rules to minimize a financial obligation, even after a clear legal decision has gone against you and the underlying court principle remains untouched.
Pension is a deferred right, not a discretionary favor, and statutory entitlements can't be arbitrarily undermined. The human stakes here are just immense. We're talking about thousands of bank elders who dedicated their careers to PSBs.
They're now forced to continue litigating well into their retirement years just to claim benefits the Supreme Court already affirmed they rightfully earned.
It's incredible.
Indeed. And that really leaves us with this final provocative thought for you to consider. If an institutional body can immediately respond to a landmark ruling, one that explicitly declared their policy arbitrary and irrational, by simply rewriting the mechanism to achieve the identical result,
What does that ultimately reveal about the limits of judicial oversight when it's faced with deeply entrenched systemic reluctance to meet a financial obligation?
the next chapter in this regulatory cat and mouse game undermines India's justice system.